May I have the appearances, please?
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning. Please state your name, sir.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not identify as that name nor consent to being called as that name.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody.
Again, I do not consent or agree to being called that name.
Your lack of consent is noted. I would note, though, you've not provided me with a different name, number one. Number two, every inmate communication form has the name Darrell Brooks Jr. I like to refer to the defendants by their name, frankly, out of respect. I know you as Mr. Brooks. Again, you've filed all sorts of inmate communication forms with that name, and you've never given me another name for which to call you. So I just want you to know that's not a disrespectful thing. It's out of respect for these proceedings.
No disrespect taken whatsoever, Your Honor. And for the record, I still would not consent to that name or agree to that name. No disrespect taken whatsoever.
Your position is noted. All right, do you have any documents to file today, sir?
Yes, I do.
All right, if you could hand that to the bailiff.
Just very brief things I would like to put on the record.
I'll have the bailiff first show it to the state. All right, the record to reflect I have received a document that has a caption for this case, a heading that says bond, then two short paragraphs, and then a signature at the bottom with the name Darrell Edward Brooks Jr., authorized representative of Darrell E. Brooks, all rights reserved. You do not reference any law. I'm not sure what you're asking me to do. I'm not going to address it any further. Do you want a copy of that for your records, sir?
Yes, I do. The time-stamped original copy, if I may. And also, to my knowledge, the filing is proper unless Your Honor can provide verified law of your own that is not a proper document. The language is all together. It's a very, very clear document in its entirety.
That, to me, does not provide a legal or factual basis for the request that you're making.
For the record, I believe it does, Your Honor.
Even with a liberal reading of that document, I'm not sure what it is you're asking me. It's not going to prevent this court from proceeding forward and continuing on with the trial.
Can you state why? Because it's clear what this is referring to. It's referring to why there's no bond mentioned or stated in the court docket sheet. Not one time does it mention it. So that was what this was referring to.
I understand what it's referring to. There's no legal basis for your argument.
This docket is not a certified copy, which is what I requested.
My understanding is a certified copy was provided to you.
This is not the certified copy that I'm holding, Your Honor.
You can take that up with the clerk of court. That is beyond the scope of what I am addressing here. The custodian of the record needs to reply to that. That is our clerk of court.
I would like that stated for the record that I did not receive what I specifically asked for.
Mr. Brooks, for the record, we're on the record. And so everything that we're saying is on the record. So with that, let's have the jury brought out. Your position's noted.
All right.
Your Honor, can we address the subject matter jurisdiction before the jury comes out?
We've already done that.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been verified?
Mr. Brooks, please, the jury's coming out. I know what you're doing, but I've already addressed that.
So is that a judicial determination that you're making?
My decision on the record stands.
I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever by refusing to answer. That is a tacit agreement by you, Your Honor, which you understand what that means. I know you do.
Mr. Brooks, I have not entered into any such agreement.
Did you have uniforms?
Yes, we did.
Can you describe them for the jury?
Objection, Willard.
Overruled. Do you have any answer?
Brown Smith.
They were long skirts. They were blue with white fur on the bottom.
If there is an objection, wait until I've ruled on it and then answer if I say overruled, okay?
Okay.
Thank you.
Overruled.
Relevant.
Grounds for the relevancy.
Keep going.
Said there's also another support person who carried ice chips. Do you know who that was last year?
Objection, relevancy.
Overruled. You may answer.
Grounds for the overrule.
I should have.
You can answer.
Okay. Yes, Bill,
Overrule.
one of our dancing granny's husbands.
Why don't you describe for the jury exactly what's in front of you?
Objection.
Overruled.
Grounds.
Okay, we have 9 people that were in the parade.
I'm going to ask that this be published and admitted into evidence.
Objection.
Does Mr. Brooks have a copy?
I believe it's up in front of him now.
Objection. I do not consent to being called that name, nor do I agree to being called that name.
Exhibit 54 is received permission to publish as granted.
Objection.
Overruled.
On what grounds?
Mr. Brooks, I'm not going to be specifically addressing. Please respect that.
For the record, I respectfully request a legal reconsideration of your ruling.
Mr. Brooks, the objection has been overruled. I expect that you will honor that, and we will continue without interruption.
I do honor it, Your Honor. For the record, I respectfully reject that ruling and take exception to that ruling.
Keep going.
Does that accurately reflect the lineup that you had on November 21st of last year?
Objection.
Yes.
Overruled.
Grounds.
Admit Exhibit 53 into evidence and publish it for the jury.
Objection.
Overruled.
Grounds for the overrule.
Ma'am, I'm going to play it straight through and then we'll go back and go through it.
Objection. Grounds for the overrule, Your Honor.
The statement continue.
Is that a legal determination that you don't have to give me the grounds for the overrule, as I have objected on the
Mr.
record?
Brooks, stop interrupting.
I ask for a written judicial finding of facts and conclusion of law. Or is that a tactic agreement, Your Honor?
Will you be able to identify each of the people if I go through the exhibit and pause it occasionally?
Objection. Hearsay.
Overruled.
Grounds for the overrule.
Not hearsay.
The left side of the street was where Lee Owen was, or the left side of the pictures you're looking at your screen?
Objection. Leading the witness.
Lee was on the left, right behind Ginny.
Miss B,
Oops.
it's okay. It's overruled.
Can you identify the person who is behind Lola and Kathy in the video?
She would be in the middle.
It's overruled.
Grounds.
That's Tamara Rosentier, and this is Kathy.
Is that Zartek?
Zartek.
Objection. Leading the witness.
Hold on, there has been an objection.
I would just note for the record, he's already said that it accurately reflects the people who are marching with the dancing grannies.
Objection. He was leading.
For purposes of identification, I'm going to instruct her to turn Exhibit 54 over.
Do you know who that is?
This would be Bill.
Bill Wilhelm? Do you know the
Objection.
last name?
Objection.
It's been rephrased.
Hospital.
And do you recall him wearing a hat that day, as shown in the picture?
Objection. Leading the witness.
Overruled.
Grounds.
Relevance.
As we were going and I was dancing, I seen a streak of red coming.
How fast was that streak of red going?
It was going pretty fast.
Hold on. The objection's overruled.
Grounds for the overrule.
Relevance.
Bill was about
Objection.
here.
I thought the sheet wasn't being shown. You specifically made a ruling for the sheet to be turned over.
She's now being asked to annotate the exhibit, so it's proper. Your objection's overruled.
After the vehicle went by, what did you do?
I just grabbed my jacket like this.
You held both sides of your jacket up to your neck area. Would that be a fair statement?
Yes,
Objection.
I think I
Relevancy.
needed.
Hold on. It's overruled.
Grounds for the overrule.
Already noted.
Not noted.
The people that you saw laying in the road, were all of those people from your group?
Objection.
Yes.
Hearsay.
Overruled. Not hearsay.
Bill Hospital. Did you go by him at all, or?
Yes,
Objection.
I talked to him.
Hold on. There's been an objection.
Oh, I didn't hear him.
It's overruled. Answer that she gave me.
I didn't even state the objection, but
Do you see a purple line on that map?
Yeah, with all the purple stars on.
Or I don't know if they're purple stars, but I see some yellow stars, some orange stars.
Yes.
objection. Leading the witness. I think
Your
the
objection is overruled.
color are pretty obvious what they are.
There's various color stars, and
There's
again,
only
the
two
exhibit's
color
been
stars.
received. Go ahead, you may ask your next question of this witness.
It has 7 names in that box. Are those all part of the Dancing Grannies?
Objection. Leading the witness.
Overruled.
Grounds.
She may
I
answer.
answer.
Go ahead.
with the exception of Bill.
Did you see headlights coming through your group?
No, because it came from the back.
I'm sorry, in the video, did you see headlights coming through?
Yes.
Objection, leading the
Yes.
witness.
Overruled.
I want to show it one more time for the jury so that they can now focus on the headlights.
Objection, relevancy.
Your objection's overruled.
Grounds. Objection, grounds.
Overruled.
Grounds.
Relevance.
I request legal reconsideration of your ruling.
Denied.
Grounds of the denial. For the record, may I request a legal or factual basis for your ruling? Is that a legal determination, Your Honor? Are you making a judicial determination?
You may continue, Attorney
Ma'am,
Basie.
did you see the body come forward and fly in front of the truck?
No, me being in
I'm
back,
sorry, in the video, did you see the body
Objection.
flying in front of the
Legal
truck? Do you know who that was?
and they had it on TV. That was
No,
the man, right?
I'm sorry.
Hold on one second. That last answer is strike it, instruct the jury to disregard it. Are you withdrawing that last question?
Yes, I am.
Okay.
Can that be struck? The question?
It's been withdrawn.
Can it be struck from the record?
It's been withdrawn.
May it be struck from the record?
Does not need to be.
May I ask for a legal and factual
Remarks
basis
of
for
the
your ruling?
attorneys and questions of the attorneys are not evidence. It's the answers that are evidence, so that's why it's not being struck.
I'm going to ask that this be admitted into evidence and published to the jury.
Objection. Where's the relevancy? Grounds
The objection's
for
noted. It's overruled.
Grounds for your ruling, Your Honor.
Relevance.
If we can play the whole 15 seconds with some. Who did that red vehicle strike in that exhibit?
Objection. Leading the witness. Saw the video.
Tomorrow,
Saw the video.
Hold on. There's been an objection, everyone. It's overruled. You may answer the question.
Grounds for the overrule, Your Honor. Grounds for the overrule, Your Honor.
Go ahead. You may
Tomorrow, Duran.
And that was the car that you saw travel in front of you?
Yes.
Objection. Leading the witness.
answer. Overruled.
Grounds for the overrule, Your Honor.
It's overruled. Next question.
Grounds.
Exhibit 152 was received already. No need to address the request for grounds by Mr. Brook due to that.
Objection. I do not consent to or agree to being called that name, Your Honor, for the record.
This clip
Would that be
is...
noted for the record, Your Honor?
Go ahead, Attorney Basie.
Thank you.
May that be noted for the
Mr.
record, Your
Brooks,
Honor.
stop interrupting.
I just want to make sure.
Mr. Brooks, stop.
I just want to make sure it's on the record.
Ma'am, is that your group in the Waukesha Christmas Parade last November?
Yes.
I'd ask that Exhibit 153 be admitted into evidence and be published for the jury.
Objection. Relevancy.
I see we may have a future granny in front of us here.
Sure looks like it.
Objection. Relevancy.
Ma'am, I'm going to give Mr. Brooks an opportunity to ask you questions as well. Please answer those for him. Go ahead, your cross.
During your testimony, you kept referring to he. Who were you referring to when you said he?
I can't understand him.
Can you please state your question a little bit louder? She was not able to hear.
I apologize. I'm sorry.
You need to be closer to the microphone or project your voice, okay?
I got it.
Thank you.
During your testimony, you kept referring to a he. Like a lot of times you would say he. Who were you referring to by the he?
He,
Yes.
when it was showing Bill,
No, not
Bill
the,
would be the he.
You stated that you saw a red vehicle strike the grannies. Do you remember if that was, or let me back up. Do you remember what type of vehicle you saw?
It was like an SUV. All of a sudden, I seen the car in front of me.
So would you describe it as a car?
It was a vehicle.
Were you able to see into the vehicle in any way?
Was I able to what?
To see inside of the vehicle?
No, because it came behind me.
So you didn't get a look at the driver at all?
No, I don't have eyes in the back of my head.
You also stated that a few of the people that were struck died instantly. How would you know for sure that they died instantly? Were you told by the police that they were dead?
That what?
Were you told by the police that they had passed away?
I could see they weren't getting anywhere.
You know that for sure.
I seen them working on them, yes.
Was it fair to say at that time that you had no medical diagnosis?
Nobody gives nobody diagnosis. They just were working on them and trying to get them revived.
So it would be fair to say at that time you had no knowledge of the injuries sustained. Stated that there was a music van or
A music vehicle.
so would it be fair to say that if a vehicle was honking a horn, you wouldn't have heard it if it was behind you?
I don't know.
Were you able to see a license plate number of the vehicle?
No. I was just shocked that a vehicle would be in the parade route. I didn't have time to read a license plate.
At one point in your earlier testimony, you pointed to the defendant table and said, "That's him from the news." Any reason why you would say that?
From the news. I didn't say that.
You pointed to the defendant's table and said, "That's him from the news," and you were cut off right in mid-sentence.
I wasn't saying that at all.
Did you ever file any claims related to the incident?
Not of the incident, no, because I was there when they were talking to the gals that weren't hurt.
The four of you, correct?
Yeah, the ones that were left, yeah.
Do you know if they filed any claims related to the incident?
If what?
Do you know if they filed any claims related to the incident?
Objections?
Grounds?
Cause for speculation?
Grounds? Do you recall seeing or reading any complaints related to the incident?
Objection?
Grounds? At any time during any interviews with law enforcement, were you shown a complaint related to the incident?
Objection?
Grounds?
Sustained.
It would be fair to say that you were asked or
Yes.
subpoenaed. Do you recall by whom?
I imagine the DA's.
When you say the DA's, do you mean the district attorney's office?
Yes.
Did they ever identify to you as being the plaintiff in this matter?
Objection.
Grounds?
Sustained.
Grounds for the substandard, Your Honor?
Relevance grounds.
Do you recall ever being told that there was a plaintiff in this matter?
No, it's just I was interviewed a few times, the five of us, and that was pretty much the end of it until months ago where
I think probably a little explanation is needed. Are you aware what a plaintiff is?
Objection relevant.
Grounds.
Sustained.
Grounds for the substand, Your Honor?
Next question, Mr. Brooks.
Grounds for the sustain, Your Honor?
Ask your next question.
I just want to know the grounds, just for the record, the grounds for the sustain.
Ask your next question.
Your Honor, the grounds should be put on the record.
Ask your next question. I'll address this all at the next break outside the presence of the jury.
Your Honor, with all respect, I think the jury
Mr. Brooks, under
deserves...
90611, ask your next question, or I will determine that the cross-examination is now closed.
I'm going to keep going. I just think the jury deserves to hear...
Mr. Brooks, I'm instructing you to stop making those statements. The jury will disregard. This is the cross-examination. It's not your opportunity to testify.
With all respect,
Next
that is not
question.
question-fine. The jury just deserves to know.
All right, under 90611, the cross-examination
I still
will
have
be
a question,
determined.
Your Honor.
Sir, you didn't follow my very clear instructions. Does the state have any follow-up?
No, Your Honor.
All right, thank you, ma'am. You may step down.
Objection to that, Your Honor.
Your objection's noted. Ma'am, you
I
may
was
step
not.
down, and after she steps down, I will be excusing the jury.
With all due respect.
Mr. Brooks, please wait. To specifically address the repeated request by Mr. Brooks for the court to state the grounds, I am not legally required to do that. Many times it's very self-evident. Either the objections are baseless, objection to hearsay is it's not hearsay. So that's why to me they're self-evident. I say sustained and we go forward. And I will caution you, 90611 is the statute, mode and order of interrogation and presentation controlled by the judge. Protect witnesses from harassment or undue embarrassment. That's the most relevant portion of 90611.
That a judicial determination that I violated 90611.
I'm advising you, sir, of why I am relying upon 90611.
I'm not interrupting you. I'm letting you make a clear record. And
Mr. Brooks, you have actually interrupted me.
I just let you go through the whole citing of 90611 without saying anything.
I'm not asking for the parties to make an argument under 90611.
So
I'm
why
advising
read it?
you. Stop interrupting me, please. I'm advising you so that you have hopefully more knowledge and awareness as it relates to the statute that I've cited dozens of times.
I'm well aware of what I'm citing, Your Honor. Well aware. I'm just seeking for the record to be clear. With all due respect, Your Honor, that's judicial misconduct because you're not allowing the jury who deserves to hear certain aspects of testimony. Under the Sixth Amendment, I have the right to face my accuser, which means that I can question about clearly the plaintiff being the accuser. How come I can't question if a witness may know or have had any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face?
I'm not further going to address your position on.
May I request a legal reconsideration of your ruling, Your Honor?
You interrupted me. I'm not done with what I was trying to say.
It was no way for me to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But you paused for quite a while, so I wasn't sure.
In any event, sir, we're going to keep going. Does the state have their next witness available? Please do not interrupt. I'm asking a question.
That's why I was just
Mr. Brooks, you're interrupting. Stop. Does the state have available their next witness?
We do, but could we please request a comfort break, Your Honor? I'm sorry, but we haven't gone about 2 hours now.
All right, that's
as long
fine.
as
We'll
they're out.
take a 15-minute break.
For the record, Your Honor, we haven't addressed subject matter, jurisdiction.
We are off the record. Then appearances are as they were before. All right, let's bring the jury back out.
Really quick for the record, Your Honor. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different.
At this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the state, or is this the military
All right,
power?
can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Thank you. Mr. Brooks, just make your statements. What do you want to advise the court today?
Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record mainly is because of the bias that's been shown. Stated for the record, you would not give me a certified copy of your oath of office. You are required to show if I ask for it. There was no record of a bond in my document. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases, based on judicial determinations made by Your Honor. My filings have been disregarded even though they've been time-stamped. As we sit here today, I'm still not even understanding the nature and cause of the charges. I don't understand why these proceedings are allowed to continue. I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members or do they have state issued licenses? That has not been proven. Nothing is certified that I get copies of when I clearly asked for them to be certified. It's to the point, Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore to protect the Constitution of the United States, you swore to protect we the people. That is not being done here. If every valid argument that I raise is taken by the court as a sign of disrespect, a sign of trying to intentionally be disruptive or causing a problem, I'm merely seeking understanding because I don't understand. And there's still no verified. There's still no proof being provided. Zero. How is this case allowed to continue without the documents and filings being verified? Just asking for Your Honor to be fair. I can go on and on and on about what's not being done. where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record, a non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Have that been placed in the evidence? I would like to see it. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. Why are we keeping information away from them that they deserve to know? That's a disservice to the jury. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I have the right to demand that the code be construed in harmony with the common law. I'm constantly referred to as pro se when I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecutor has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. The first time I came before Your Honor in early March when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied. I still don't understand how that was denied. There's no possible way anyone in this county would not have some type of connection. There's no way that this trial should be taking place in Waukesha County. That's obvious. The coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated. I don't know if it was to you becoming a judge. I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge their family member was injured in an incident, that you reached out via phone. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs and I know what professional relationships is and personal relationships. That would constitute a personal relationship of some kind. It would definitely be more than just strictly professional. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? It was understood by the court. This is my first time ever having to do this. I didn't understand how to properly fill out the subpoena, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this, but I still complied to what the court asked them. And even then, there's a big old thing about the subpoena. I can't subpoena the plaintiff. Could the subpoena not be filed? And how could the plaintiff not be called to the witness? That begs the question, does the plaintiff even exist? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why would you not state the name that is on file with the Secretary of the State? You referred to your name tag, but that's not the name registered. We both know. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that it's the true oath of office that you signed? I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant? Every filing up until the point that I started representing myself in a name that was represented by all capital letters, which is not my name, nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that. I'm merely here as a third-party intervener on behalf of my client that I accept for value in return for value. We go through this every time I come here. Every time. You bring the Illinois versus Allen. When we had the issue of me being removed from the court, Illinois versus Allen states there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one. So the question would be, did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present, not upholding my constitutional rights? I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. I gave you back that paperwork that I altered. You accepted it and you filed it. So when you accepted that with no objection, that becomes a tacit agreement. But yet I'm still forced to come in here with zero help. Per Jail Administrator Angela Wallenhoff, I'm roughly locked down 22 hours a day, not given the privilege to access everything that I should if I was general population. LexisNexis or whatever it's called, we call it the law library. It may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. I even suggested some type of order that could be made by the court to allow me more time out of my cell. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. There were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is that I have children too, family too, that also have been ridiculed and had their names drugged to the mud and have threats towards them. Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. To constantly report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult, but it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, it's not only hurtful, but it's insensitive and it's not true. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious. There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times. So I'm going to turn to the state to see if they have any response.
Mr. Brooks,
Objection.
knowingly,
I consent to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself. The court patiently advised him of many of the things he's complaining about here today, the resources of the state, his ignorance of the law, and his words to this court, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely. This court has been exceedingly respectful of his rights at every turn. I want to address this claim that he only had 3 days to prepare for trial. He does have 3 banker's boxes on his table. Every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their cross-examination questions and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial. And on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. And again, you warned him, Judge, and he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're going to say, but that's a load of crap.
Mr. Brooks.
For her to sit there.
Mr. Brooks.
For her to sit there.
Objection is noted.
For her to sit there, Your Honor.
No, it's my turn. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. Please listen and please do not interrupt. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections. The issues you raised regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court is frivolous. Those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, they're baseless, and this court need not address them further. So I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. There still hasn't been.
As noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr.
any
Brooks,
proof.
I've addressed them
There
to the
still
extent
hasn't
that I
been
will.
The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything along those lines. I'm not going to address it any further.
Because there's no verified proof.
There does not need to be, sir. All right, I
It does
believe the
need to
jury
be.
is coming out. Is that true, Madam
In order for a case to
All right. The
To
record
go
should
on, there should
reflect
be
that the
proof.
jury is coming out, and we are about to continue with the state's next
Not once
witness.
was the plaintiff addressed. That wasn't addressed. Where's the plaintiff? Where's the injured party? That's because
The jury will disregard the statements presently being made by the defendant.
because y'all don't want the jury to know the truth.
The jury will disregard those
I
statements
understand.
made by the defendant.
I see.
It is not his opportunity to testify. They are comments, and as such are to be disregarded.
I see what's going on. Ain't gonna work.
All right. Thank you, everyone. You may be seated.
It's not gonna work.
Is this the recording that your daughter captured that afternoon?
Yes.
Move to admit number 139 and permission to publish?
Objection.
Ms. Evans, is that what you remember seeing that afternoon?
Yes.
Mr. Brooks may have some questions for you.
Any cross?
Yeah, and I object to being called that name again, and I don't consent to it again for the record. Just a few questions. Do you recall it being pretty loud?
Every parade I've been to has been loud in general, so
So it'd be fair to say that that one was pretty loud.
yeah, I suppose.
Did you hear at any time a report of shots fired? Did you hear any shots?
It was loud and chaotic. I can't say for sure if I heard shots or not.
So would it also be fair to say that if a horn may have been blowing, you wouldn't have heard that either?
I would have heard a horn. We weren't that far from where the vehicle came through.
So it'd be fair to say that you think you would have heard a horn, but not shots.
I didn't hear any shots when the car went past.
No, I'm not asking when it went past. The question was at any time. At any time. Any time during that moment.
I don't believe I heard gunshots. I've never heard a gunshot before, so I can't really say yes or no.
Seeing as how you've never heard a gunshot before, would it be fair to say that it might be really loud?
I've never heard a gunshot.
Did the district attorneys ever tell you in any way that they were the plaintiff in this matter?
Those words were never spoken to me.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Next question.
Did you file any claims on the matter?
With who?
Do you understand the question?
Not really.
Please rephrase.
At any time, did you file a claim with any, I guess, agency or anything like that?
No.
In regards to the incident?
No.
Did any information that you obtained in regards to this incident have a complaint with it?
Objection made.
Grounds.
Sustained is to the form of the question.
Do you know of any complaint with this incident?
Not sure I completely understand the question on that. What kind of complaint?
Have you ever seen any issued charges in relation to this incident?
I'm sorry,
Grounds?
I did not understand what Mr. Brooks just asked, Your Honor.
I believe he said the issued charges.
I object to that on relevance grounds, Your Honor.
Grounds. Are you aware of anyone bringing any claims or suits?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Next question, please.
Just for clarity, you are not aware of any plaintiff in this matter, correct?
Asked and answered.
Grounds. Is that an objection?
Sustained.
Do you recall before August being contacted in connection with this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Next question, please.
No grounds.
Next question, please.
Would you consider yourself an injured party in this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds.
Sustained.
Reason for the sustain, Your Honor.
Next question, please.
No further questions. Here's the free subject matter jurisdiction, Your Honor. Still have yet to be verified.
Your objections noted.
We came up with the average speed of the vehicle of 32 miles an hour. We wanted to find an exemplar vehicle just due to the type of case this was. They were able to easily locate one.
You used a 2010 red Ford Escape?
Correct.
Okay. Do you happen to know the curb weight of that vehicle?
Yeah,
Overruled.
3,368 pounds.
Can you say definitively that at any point between point A and point B, the vehicle was traveling faster than 32 miles an hour?
Objection, hearsay.
Overruled.
Grounds. Grounds.
So is it possible the vehicle maintained a constant speed of 32? Yes. But it's more plausible that you have higher and lower speeds during that segment.
Any reason why the average speed wasn't depicted in the exhibit?
That's just a calculation that we do that's included in the report. I don't normally do that in the diagram.
So it would be fair to say that you created the diagram?
I did create the diagram, yes.
And normally you don't put the speed calculation in the diagram. Would there be any reason for that?
It's in the report. It's not necessary to put it in the diagram.
Have you ever done that before?
Could you rephrase the question?
Have you ever not included the speed analysis in any crash reconstructions that you've done before?
Are you referring to the diagram or
Referring to the diagrams.
No, I don't. I do not put speed calculation results in diagrams
On any of them.
on any of them.
Did you create any diagram with the speed calculations present on it?
No, I don't. The diagram that I created is the one that was up on the screen.
Would it be fair to say that it may be a little bit difficult to locate what you analyze for speed if it's not in the diagram?
No.
If you wanted to know the calculation of the speed, you would have to read the report.
Correct.
Would it be fair to say that it might be easier to find if it was included in the diagram? You made reference to something called Newton's Law. Can you explain a little bit further what that is?
Sir Isaac Newton obviously invented the laws of motion. We all learned that in high school, and that's part of the process that came to the formula that I used to calculate the average speed.
I always thought of Newton as gravity, so that was a bit of new information. You made reference to part of the crash reconstruction was finding a similar vehicle being in the parade as well?
The exemplar vehicle?
Yes, the vehicle that was similar.
The exemplar vehicle was not in the parade.
I may have misinterpreted what you were saying. A lot of technology went into getting the diagram created and, different variations of that. And then also using a similar vehicle to, I guess, simulate. Would that be fair to say, simulate the incident?
We used the exemplar vehicle for our testing.
Was that done all the same day or was it done?
Sorry, could you
different
rephrase
time?
the question again? I'm not understanding what you're asking.
Was the creation of the diagram and the simulation of the vehicle done on the same day?
No, it was not. The testing was done on January 30th.
And what about the simulation from the similar vehicle?
I'm sorry, could you rephrase the question?
Do you recall what day the simulation was performed? Specifically the part of the similar vehicle being used?
That was January 30th. We did the testing out on Main Street in front of Curry Insurance.
Did you perform an external examination of an individual identified as Leanna Owen?
Yes.
These autopsy protocols were previously provided to the defense.
All right, we'll still make copies.
I accept for value in return for value these documents shown.
I did provide Mr. Brooks a copy of both the autopsy protocol as well as the diagram that's going to show on the screen.
Objection, I don't consent to being called that name, Your Honor, for the record.
Can you describe the fatal injuries for the jury?
Objection, leading the witness.
Overruled.
Would all those injuries be consistent with being struck by a moving SUV weighing approximately 3,300 pounds?
Objection, hearsay.
Overruled.
Yes.
The autopsy protocol for Virginia Sorensen as well as the diagram both been provided to Mr. Brooks.
Objection, I don't consent to that name, nor do I agree to it.
Did you perform an external and an internal examination of Ms. Sorensen?
Objection, leading the witness.
Overruled.
Yes.
Can you describe for the jury which injuries were fatal injuries?
Virginia
Objection, leading the
Sorensen.
witness.
Overruled.
And is that consistent with being struck by a moving SUV weighing approximately 3,300 pounds?
Objection, hearsay.
Overruled.
Yes.
For the record, the state did provide Mr. Brooks with a autopsy protocol for Jackson Sparks as well as the diagram. Ma'am?
Objection, I do not consent to that name, nor do I know that individual, for the record.
Please continue.
What was his cause of death?
Complications of craniocerebral injuries due to blunt force trauma to head.
Would that be consistent with being struck by a moving SUV weighing approximately 3,300 pounds?
Yes.
Objection, hearsay.
Overruled. Cross-exam.
1 second.
Mr. Brooks. Your cross, please. Do you have any questions for this witness?
Just 1 second. I apologize to the court for taking so long. Do you know why the decision was made for Jackson to become an organ donor?
Objection is irrelevant.
Sustained.
Those the only 3 autopsies that you did.
Yes, Jackson Sparks, Virginia Sorensen, and Leanna Owens.
Or are you called to attend to any other victims of the incident? Or just the 3?
Jackson Sparks, Virginia Sorensen, and Leanna Owens.
You didn't attend to anyone else?
Objection has to be answered.
Grounds.
All right, thank you, Dr. Shield. You may step down.
Your
Say
Honor.
by call. Sorry?
Your Honor, if it pleases the court, may I have a few moments?
We can take a short break. All rise for the jury, please. All right, it's 2:13. We'll be in recess for 10 minutes. Thank you.
Just we'll briefly touch on the subject matter jurisdiction again for the
The
record.
court will not be addressing that. Please bring out the jury.
Were you aware that this was as a result of an incident that occurred in downtown Waukesha?
Absolutely.
Overruled.
I'm going to give you a pointer. I think it's hard maybe for the jury. I'm having a hard time seeing some of the dots
Okay.
on the skeletal diagram.
Objection. Relevancy it is.
Overruled.
Grounds for the overrule.
Relevant.
Moving next to the autopsy that you performed on Jane Kulik. Is that consistent with Ms. Kulik being struck by a moving SUV weighing in excess of 3,300 pounds?
Yes.
Objection. Hearsay.
Overruled.
Your primary field is in the medical field. Any reason why you would be inspecting a car if that's not a medical professional thing?
The examination of anything that's related to injuries and the people that I later examine is relevant.
Examining the vehicle would be essential to your medical expertise. Is that fair to say?
Examining the vehicle is important to interpret the injuries.
If the injury was caused by a different kind of instrument, would the same apply to having to view that?
Yes, in cases of gunshot wounds, I asked to see the gun.
In the case of a gunshot wound, as you brought up, let me back up. Would you say it would be hard to assess the gun, being that it wouldn't be the actual gun, but the bullets that caused the injury? If it was a muzzle type thing, the mark would be from the heat. Would that be fair to say?
No, it's actually from the contact of the metal, so it's more of an abrasion than a burn.
In a case like that, what would be the significance of the actual inspection of the gun?
I'm going to object to this question. I think it's a little bit afield of where we're at.
Grounds.
Overruled. She may answer. She brought it up as an example.
What if it was used from a distance? Then what would be the essential reason to inspect the gun? Do you know if any of the victims you performed the autopsy on had any underlying illnesses at that time?
Well, Mr. Hospital, he was an older gentleman. He had some heart disease, a pacemaker. Ms. Kulik had a large fibroid.
Can you explain to the jury what is a large thyroid? Is that the word you, thyroid?
Fibroid. It's
Fibroid.
a benign uterine tumor.
Is that a form of cancer?
No,
The older gentleman had some type of fluid around the chest area.
correct.
From your recollection, that wasn't caused by the vehicle?
That was because of the blood loss. The fluid collected as a rupture of that thoracic duct injury.
And you said he had a pacemaker. Would that have any effect whatsoever on what might have been going on in his chest?
No, and because he was in the hospital, the function of that pacemaker was well documented.
Was it pretty active, still working properly at that time?
It was.
Even with the loss of blood, as you say? He had a loss of blood. Even then, was it still working pretty good?
Yes, the loss of blood had no effect on the electrical function of the pacemaker.
Do you recall whom you were subpoenaed by?
The district attorney,
Would that be referring to one of the district attorneys here today?
Sue Opper.
Did Attorney Opper ever state that she was the plaintiff in this matter?
Objection.
Grounds?
Sustained.
Grounds for the sustain, Your Honor.
You may ask your next question.
Were you ever made aware of the plaintiff in this matter?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain, Your Honor, before I continue.
Ask your next question.
Do you even know if there's a plaintiff in this matter?
Objection,
Grounds?
Sustained.
Reason for the sustain, Your Honor?
Ask your next question.
No reason for the sustain, Your Honor?
Ask your next question.
Do you know of any claims filed in this matter?
What are claims?
Any reports filed, any filings made on your behalf or anyone you know?
I'm actually not sure I understand that.
I would object to it. It's vague.
Grounds.
Sustained.
Did you make any claim of being an injured party in this matter?
No.
Do you know of anybody that has?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Relevance. Speculation. Vague.
Have you ever at any time had any interaction with the plaintiff in this matter?
Objection.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Vague. Relevance.
I would object to that sustain. You said vague and relevance, relevant to the
Sustained.
case.
Next question.
It's relevant, Your Honor.
Your
Jury deserves to know.
objection is overruled.
I respect that. Jury deserves to know, though.
Jury will disregard the last statement made by Mr. Brooks. It's not his time to testify.
Have you ever seen the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Same as before.
So that would be relevancy and vagueness.
Ask your next question.
Was today your first time ever seeing those exhibits? You've seen those before, those videos?
Videos?
Yeah, the exhibits that were shown.
Diagrams?
Yes, I didn't know that's how you identify them.
Oh, well, I drew them.
I'm assuming at some point you turned those over to the district attorney. Would that be fair to say?
Today.
Oh, today. That's interesting. So this was really like a 11th hour bottom of the night thing for you to get them prepared and be ready to go today then. Would that be fair to say?
No, I wouldn't say that.
Had you ever created any diagrams like that before?
I've used diagrams in many, many trials. I just didn't have a diagram that displayed the body and the skeleton in this manner.
So for this particular case, you decided to go a little bit extra. Would that be fair to say?
Objection, argument.
Grounds.
Sustained.
The way that you designed these particular diagrams, had you thought of doing it this way before this particular incident?
Objection is irrelevant.
Grounds.
Sustained.
Grounds for the sustain, Your Honor?
Next question, please.
It's Halloween, so we see them all over the place, but could you have brought in a skeleton and described the same injuries?
Objection, relevancy.
Overruled. It's
Objection,
redirect.
hearsay.
It's not hearsay.
Jane Kulik's autopsy. You had stated that you had discovered a benign uterine fibroid. Was that a factor in her death?
Objection, hearsay.
Overruled.
No.
And with regard to Wilhelm Hospital, was the presence of a pacemaker in any way related to his death?
Objection, I asked that in my cross and she answered.
Overruled. It's redirect. It's proper.
No.
The thoracic fluid found in Mr. Hospital's lungs that you said did play a factor in his death. What caused that fluid buildup around his lungs?
Objection, answered already.
Overruled.
It was an injury to the thoracic duct that was caused by the impact by the vehicle.
That appears to be the street that you guys
Exactly.
walked on
Yep,
and the clothing
definitely.
that he was
Objection,
wearing.
leave the meeting.
Overruled.
Can you identify the individuals who are named in this exhibit?
Objection, the names are on there.
Question was whether he could identify the individuals who are named. So
That's a big arrow pointing to there.
your objection overruled.
I'm going to show you what's been marked and admitted into evidence as State's Exhibit 15.
Objection, how many times do we need to publish the same picture?
Your objection's overruled.
Of course.
Do you recognize the names that are on that map?
Objection, leading the witness.
Overruled.
Yep, I recognize all those names.
Could you estimate the speed?
Objection, hearsay.
Overruled.
And the speed limit was 25. The car, in my estimation, was going faster than I would see a car driving in normal times down that street.
So in excess of 25 miles per hour?
Objection, hearsay, leading the witness.
Not hearsay. It's a clarification question. It's overruled.
I would say yes.
If you saw them either that night or in the following days, let me know, and if you could just, if you know that they were injured. Maria Alvarez Dominguez.
Objection, it's hearsay.
It's not hearsay, so you may
injuries
answer
will
the
be hearsay.
question.
And how about Gregorio Romelia Perez?
She was very, very, very severely injured.
Could you observe what those injuries were?
Objection, hearsay.
Overruled.
Jason Pekloff.
Objection, hearsay.
Overruled.
Yamilet Perales Alvarez.
Objection, hearsay.
Overruled.
Jose Perales Alvarez.
Objection, hearsay.
Overruled.
And Camila Perez Gonzalez.
Objection, hearsay.
Overruled.
Camilla had an orthopedic injury. She's had a number of surgeries.
Any cross-exam questions?
I do.
Please proceed.
Wait a second. I don't have too many questions for you, Father. Any reason why you would be testifying on behalf of an injured party if you are not an injured party?
Objections.
Grounds.
Overruled. You may answer.
My thought would be, or have a more wide-ranging kind of knowledge of different people's situations as a pastor. That's what I would assume. But
You testified to observing quite a few injuries. How can you assess the injuries just by looking at the people?
can you clarify what you mean by that? Like, what are you getting at?
For example, if I was to see someone injured laying on the ground, I could essentially say, oh, it looks like this. But how can I be certain that that's what it is? Would it be fair to say that you were told those injuries either by medical professionals or by the people?
Exactly. So if people would say, this is my injury, I would believe them. If they'd be in the hospital, if I see people with crutches, wheelchairs, then I would say that's probably accurate.
But you didn't know for sure yourself until you were told.
Yeah, I'm not a doctor, so I'm not the one diagnosing an injury. I see people with crutches, wheelchairs,
That's what
and
I
I'm
was
like,
getting at.
there's probably truth there.
Do you know if any of the people you saw after the incident filed any claims in the matter?
Could you clarify by what you mean by claims?
To be an injured party in the matter, or did they file for any medical bill support or anything of that nature?
There was the Waukesha parade fund that was, I think, an international type of thing. So there were different encounters to allow people to come together and talk about what had happened, start healing from the emotional part of it.
By international, that would be assuming worldwide. That'd be fair to say?
Yes.
So it would be fair to say that there were financial interests attached to this incident.
Objection is how it relates to this witness's testimony.
Grounds.
Sustained.
Well, it was actually because it was a wide-ranging scope by him saying international.
What's your question? I sustained the objection.
Was there any financial interests attached to this incident?
And I'm going to object for the same reasons before.
Grounds.
It's vague, unclear, overly broad.
You refer to it as a car. Was it a car? Was it an SUV? What was the vehicle?
I would describe it as an SUV to be specific.
Any reason why you would say car?
Objection argumented.
Grounds.
Overruled. He may answer.
The people that know me, I'm not a car person, so car is a wide-ranging descriptor to me.
Would it be fair to say you wouldn't call a bus a car, though, right?
Objection argumented.
That's argumentative. Sustained.
At any time when the vehicle was passing you, were you able to see into the vehicle?
The vehicle was going very fast, so I would not have had a picture of who was driving the vehicle.
But you can't estimate a good speed that the vehicle may have been traveling.
My estimation was faster than I would usually see a car traveling down Main Street, so over 25 miles an hour.
Even if there was no parade, if it was just a normal day.
That's what I'm saying. The car was traveling faster than you would see a car traveling on a normal day.
Were you in contact with any law enforcement about this incident leading up to the October 1st subpoena that you received?
Not before I talked to the DA.
And do you recall what DA that was?
That was Susan.
Excuse me.
Susan.
May the record reflect that there was a right-hand gesture towards the prosecution table?
I believe the witness identified our District Attorney Susan Opper as the Susan.
Was that October 1st time the only conversation you had with Attorney Opper?
It would have been sometime in September.
And at that time in September, you weren't yet subpoenaed?
This would be a point of clarification in the sense of I believe it would be more than come in if you want to. I believe it was kind of like you need to come in, not if you want, you can, if not, don't. I'm not sure what the terminology for that is. If that's a subpoena.
No, that's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something which would be testifying, which you cannot do at this time. So the jury will disregard his last comment.
Something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions for this witness? Please ask them.
During your conversations with Attorney Opper, when you received the subpoena, were you provided the complaint in this issue?
What do you mean by complaint?
The complaint would be a reference to the charges in this matter.
Objection made.
Grounds.
Overruled. He may answer.
To me, seeing what happened and seeing everyone that was hurt,
No.
To me it was very obvious what this was about.
Did you see any paperwork related to the charges in this incident?
So there'd been the subpoena sheet that would have had your name.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks.
Are you aware that I don't identify by that name?
Objection argumented, sir.
Sustained.
Sorry.
Are you aware of who the plaintiff is in this matter?
Objection relevance.
Grounds.
Overruled. He may answer.
I believe that you would be, or excuse me, you're the defendant.
I would be the plaintiff?
Excuse me, at my mind, you're the defendant, I believe. The plaintiff would be, all those who were hurt under the title of the state of Wisconsin. That's how I would identify it.
That's how you identify it. So, do you know if anybody who was hurt that identified as the plaintiff?
Objection relevance.
Grounds.
I think this witness has testified he's really not sure what the plaintiff is. He kind of guessed. He gave an assumption.
Sustained.
He did answer the question, though.
Sustained.
So, to the best of your knowledge, the plaintiff would be a representative of the people.
Objection is relevance.
Sustained. You're now asking him to make a legal conclusion, which I will not have him do. It's also not relevant.
Do you know if any injured party who claims to be the plaintiff in this matter?
Objection relevance.
Grounds.
Sustained. Mr. Brooks, under 906.11, please move on to a new topic.
Are you aware that only an injured party could be the plaintiff in this incident?
Objection
Grounds.
relevance.
Sustained also misstates the law. Mr. Brooks, new topic, or under 906.11, I will close the cross-examination.
How does that mischaracterize the law? An injured party has to make the claim.
Under 906.11, I will give you one more opportunity. The jury will disregard his statement as it mischaracterizes the law.
Are you aware that the state of Wisconsin is an entity and cannot claim to be an injured party in this matter?
Objection.
Ground.
Sustained. Your cross-exam is now closed.
Prior to the red SUV coming through your group, did you ever hear a horn honking?
Objection.
Overruled. You may answer, sir.
Objection. Hearsay.
It's not hearsay.
I personally didn't.
Objection. What was the answer to the last question?
The record speaks for itself.
When you spoke with District Attorney Susan Opper, did she ever tell you what to say today?
Objection. Hearsay.
Overruled. You questioned his credibility. You questioned his talking to the state.
Attorney Opper is not asking the question, so how would Attorney Basie know what
Mr.
Opper
Brooks,
said?
I'm not going to explain the legal procedures.
She did not.
Okay.
No.
Did she tell you to tell the truth today?
Objection. Relevancy.
Everything that you testified today, is it truthful?
Objection. Hearsay.
Overruled. You may answer.
Yes.
All rise for the jury. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks,
telling them the truth.
stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to.
Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced. We are in recess. We'll be back in
And
5
prove it.
minutes.
I don't agree to a estoppel. Can you prove it?
Let me say this, Judge. The ebb and flow of this trial has been very difficult to predict, not through any fault of the court, but by events. We do have 2 witnesses here ready to go. If the next witness goes relatively smoothly, would you consider letting us call the second one and maybe wrapping up by about 6 o'clock?
Yes. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes.
We're going to make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No, we cannot.
Talk about that. We're not going to address that either. That's still not going to be proven, right? It was frivolous stuff. That's going to get pressed every time. So I've yet to prove subject matter jurisdiction. Any jurisdiction at all, rather.
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not.
Could you describe for the jury if the screaming stood out to you?
Yes, it was.
Leading the witness.
Overruled.
And did you notice anything different about your surroundings as you heard the screaming?
Objection. Asked the form of that question and it was answered.
Overruled.
Can you just repeat the question, please?
Sure. Do you notice anything other than the screaming that seemed unusual when that happened?
Objection. Different question.
Overruled. I'm not sure what the objection is.
Clear with the objection.
Which shoulder did you look back over when you heard the screaming?
Turn to my left.
And that's when the vehicle was approximately 200 feet away?
Objection. Hearsay.
Overruled.
Yes.
Benjamin, is he the 7-year-old?
Yes.
And he was in front of you?
Objection. Leading the witness.
Overruled.
What's the name of your 9-year-old?
Elliot.
Objection. Relevancy.
Overruled. I'm sorry, what was the name?
Elliot.
Thank
Elliot
you.
Hallmark.
Could you estimate the speed that the vehicle was traveling?
Objection. Hearsay.
Overruled.
About 30 to 40 miles an hour.
Does it accurately reflect what you observed on November 21st, 2021?
Yes.
Objection to the relevancy.
Overruled.
Does this video contain footage of the Waukesha Catholic community in the parade on that date?
Objection. Hearsay.
Overruled.
I would move State's Exhibit 140 into evidence and ask that it be published to the jury with sound.
Objection. Still hearsay.
It's overruled.
Where is your witness at?
So I'm going to show you some still shots from that video and just ask if they accurately reflect what you observed.
Objection to the relevancy.
And are there names on this diagram? Do they appear to be associated with people within this group?
Objection. Hearsay.
Overruled.
Yes.
Okay, I'm going to ask that Exhibit 135 be admitted and published to the jury.
Objection to the relevancy.
Overruled.
If you can describe for the jury what you're seeing.
Something very similar to the last exhibit.
Is there an objection?
Leading the witness.
That's not leading. It's overruled.
And do you see yourself in this photograph?
I do.
I would ask that this be admitted and published to the jury.
Objection. Where's his name if he's in the video?
That's not an objection.
Can you circle where you're at?
Objection. What's the
Overruled.
relevancy of it?
Overruled.
And would this be consistent with what you believe generally the formation would have been when your group was impacted?
Objection. Hearsay.
Overruled.
Yes.
I'd ask that Exhibit 137 be admitted into evidence and published.
Objection. Where's the relevancy?
Overruled.
Do you see a purple line on that exhibit?
Yes.
What does that reflect?
Objection. Name
Overruled.
the witness.
The parade
Hold
route.
on, sorry, what was your
Name the
objection?
witness.
Leading, did you say? Overruled.
Are all those people that are listed in that box, were they in the roadway at the time that the red SUV went through your group?
Objection. Hearsay.
Overruled.
Yes.
I'm going to show you approximately 20 seconds of the clip. Does that accurately depict what occurred near your group, the Catholic community?
Objection. Hearsay.
Overruled.
Yes.
The 4 people that you saw sliding through the screen from left to right, did you recognize those people?
Objection. Hearsay.
Overruled.
Can you identify each of the people that are shown in this still shot?
Yeah.
Objection. Leading.
Overruled.
I'm going to play the first 5 seconds for you and ask you if it depicts on what you observed on November 21st of last year.
Objection. What's the relevancy?
Overruled.
Are you able to identify many of the people in this video clip?
Objection. Hearsay. There's a
Overruled.
lot of people in here.
It's not hearsay.
Where's Elliot? And you recognize that to be the position you went to when you found him?
Objection. Hearsay. We can't see who that is.
It's not hearsay. Overruled.
Yes.
We can pause here. Do you recognize that person?
Objection. Hearsay.
Overruled.
Is that still Marisol?
Objection.
We can pause here.
Pause. Who is that if you know?
So this is still
Said
Marisol.
objection.
Overruled.
Do you recognize this person? And is that how she appeared on November 21st of last year?
Yes.
Objection. Hearsay.
Overruled.
And is this a picture taken from a video from the parade?
Objection. Hearsay.
Overruled.
Yes.
I'd ask that the court admit Exhibit 162 into evidence and publish it to the jury.
Objection. Hearsay and relevancy.
The objections are overruled.
Can you point her out and the hat that she's wearing on her head?
She's wearing some sort of like maroon colored hat.
If we can save this screen capture.
Objection. Relevancy.
Overruled.
Is that the same type of hat in terms of, has the same wording on it, same color, same palm color as the hat Eileen was wearing?
Objection. Hearsay.
Overruled.
It looks remarkably close. Yes.
Right, you're crossed.
So you saw all those videos, exhibits rather, all 12, 13 of them before today?
I don't recall there was 12 videos, to the best of my knowledge.
126, 15, 137, 136, 135, 140, 178, 160, 154, 162, 92, at least 11 or 12.
Mr. Brooks, I'm going to strike your comment because you cannot testify. You did not let him answer.
I believe there was only 3 or 4 videos, but there was numerous screenshots or photos taken from those videos.
That's why I said exhibits. Have you seen all exhibits before today? Did you view all 12 of them in their entirety?
Yeah, that's the form of the question.
Grounds.
Did you view them all in their entirety? It makes it seem like he's referring to videos, and if he is, that's fine if he can just clarify videos or exhibits.
Exhibits.
I don't recall specifically. I just reviewed the photos as you're explaining in these exhibits prior in preparation of my testimony.
In preparation of your testimony? What do you mean by in preparation of?
Making sure that everything is accurate in what I'm going to testify to.
If everything you're going to testify to is truthful, why would you need to prepare for it?
Objection.
Grounds.
Sustained.
Wouldn't it be easy to just come in and recount what you saw?
Objection. Argumentative.
Grounds.
Sustained.
So why exactly did you feel the need that you had to prep yourself?
Objection. Argumentative.
Grounds.
Sustained, also asked and answered.
I'm going to direct your attention to Exhibit 154, which is a video. So that's clear for the record, not a still frame. I want it put up for him. Can we go to 41 seconds?
Sure. Thank you to the state for assisting.
In this exhibit, which is a video that's paused at 41 seconds, we can see 2 people laying on the ground. Can you see any of the 2 people's faces right now as it's paused?
No.
So it would be fair to say that you can't positively say who that is from this part of the video.
Obviously, Adir and Marisol are mother and child, and body structures, that's how I'm able to identify who they are.
What do you mean by body structure?
Well, Adir is a little bit smaller, and Marisol is a little bit larger. I'm pretty confident that's Marisol and Adir.
Pretty confident?
I'm very confident.
So why not be very confident the first time that question was asked?
Objection.
Grounds. Grounds.
Sustained.
Let's go to 58 seconds and pause. Can you see the face of the person laying on the ground under the pink blanket?
No, sir.
Would it be fair to say that you don't know for sure who that is?
I'm very confident that that's Marisol that's laying on the ground.
And how can you tell that from the picture that we're looking at now?
Well, not specifically just from this picture, but as the video was moving, you could see clothing descriptions, body structure, who she's laying next to.
Is it fair to say that the exhibit is not moving right now? It's paused. Not being able to see who's under the pink blanket. So how can you say for sure who that is?
If I was to just view this photo without any other context, you're probably correct. I probably wouldn't be able to identify any particular person, but because of the video and how it moved and how I was able to see people, I was able to confirm that'd be Marisol.
Can you tell who that is just looking at it right now?
Well, I know that that's Gregoria, yes.
Can you tell who it is looking at it right now? Can you see their face? Can you identify them right now?
I cannot see their face.
So it'd be fair to say that you're not sure who that is.
I am sure who that is.
And you come to that conclusion based on what we're looking at right now at this moment.
Objection.
Grounds.
Characterizes this witness's testimony.
Grounds.
Sustained.
Based on what we're looking at right now on the screen, can you tell who that is? You
Yes,
can
sir.
see their face.
I know who that is. I cannot see their face.
So it'd be fair to say from this picture, you're not sure who that is.
Objection. This characterizes
Grounds.
this witness's testimony.
Sustained.
To the right of the screen, right here, it's obvious that they're attending to somebody. Can you see who that is that they're attending to in any way?
Not from this vantage point, no.
So it'd be fair to say that you don't know who that is that they're attending to, correct?
I know who they're attending to.
And you can tell that by what we're looking at right now?
Objection.
Grounds.
Characterizes the testimony.
Grounds.
Witness testified who he believed each person was.
Who he believed. Can you tell from what we're looking at right now who that is that they're attending to?
You cannot see that that is Jason Peshoff behind them.
And you can tell that by what we're looking at right now.
No, based on my recollection of the incident is why I know who that is.
I'm saying referring to what we're looking at, not your recollection. What we're currently looking at right now.
You cannot see who the individual is.
And we go to 2 minutes and 30 seconds and pause. We can see a group of people standing over someone that appears to be laying on the ground. It looks like they have a Scooby-Doo blanket over them. Would that be fair to say? By what we're looking at right now at this moment, can you tell who's under the Scooby-Doo blanket?
I know who that is.
Can you tell by what we're looking at this moment? At this moment right now, can you tell who's under the Scooby-Doo blanket? Can we go to 241 and pause? You can see that someone's laying on the ground and you see 3 people attending to them. Can you tell by what we're looking at right now exactly who that is?
100% confident because I'm in that photo.
And is that you standing over the front of them?
I'm standing over my son.
Or not standing, I'm sorry, I didn't mean to cut you off. Kneeling in over the top of who's on the ground.
Yes, my son is crying because he just got struck by a vehicle and I'm trying to console him.
That wasn't the question. You were 100%. You were adamant, 100% that you knew who that was. But you didn't have that same enthusiasm for everybody else that we were just looking at. Would that be fair to say?
Objection. This characterizes this witness's testimony.
Grounds.
Sustained. It's also argumentative.
In a summary of your report, do you recall stating that you saw a second unconscious person laying on the ground that you further described as a Hispanic female? Would it be fair to say that in your testimony here today you gave names? Why not in the summary of your report?
I'm just going to object to the form of the question. He's indicating that it's Detective Hallmark's summary in this report. It's not been established.
At the time of your summary, did you know the identity of the Hispanic female?
An objection to the form of the question. It's not his summary per se.
Sustained.
So should I say in the summary that you gave, do you recall that comment?
Objection. This characterizes the summary.
Grounds.
Sustained as to the form of the question.
In the summary that was given by the officer that you gave the report to, do you recall that?
I am going to object. I believe what Mr. Brooks is looking at is a different officer's report that summarizes the statement from Detective Hallmark. I would ask Mr. Brooks to maybe ask his next question, keeping that in mind.
Objection to being called that. I don't identify by that name nor consent to being called that name. And
Next question, sir.
I made reference that it was
Next
by
question.
another officer.
Next question, please.
Who is Charles?
That'd be my 3-year-old.
And Benjamin?
That'd be my 7-year-old.
Do you at any time recall making a statement in the summary that was given by another officer? You threw Charles and Benjamin as hard as you could towards the south curb. You threw your 3-year-old, and you also acknowledged that you threw Benjamin.
Objection as to the characterization. The summary that Mr. Brooks is reading said that he threw Benjamin.
He answered the question.
He did not. I'll sustain it as to the form of the question.
So did you throw Benjamin as hard as you could to the south curb, or did you see Benjamin struck by the vehicle?
The vehicle was coming and I threw Charlie. I knew that Ben was in front of us, so it was the same motion with my left arm to get Benjamin and Charlie out of the way. Obviously, I didn't get Benjamin completely out of the way of the vehicle.
Any idea why that was not in the summary?
I don't recall.
Wow.
Sir, the identifications that you made in the exhibits that were shown to you on direct examination, are you 100% confident in those identifications?
Objection. Hearsay.
Overruled.
What is that based on?
My recollection of the incident.
Thank you. Nothing further.
Mr. Brooks, those things were provided to you?
I accept the value in return for value these filings. Just very briefly so we can get out of here. I have to raise this issue.
What issue is
My understanding, how can someone who's not an injured party testify on behalf of somebody who is an injured party?
Mr. Brooks,
and it still be
I'm
charged?
not addressing this. You have a misunderstanding of the law. We are in recess. I am leaving the bench. Thank you, everyone. We're in recess.
So that's a tactic agreement. We're not